I think we're a little bit early, but I think we're going to go ahead and get started. So welcome everyone to the Court Community Connections program here in beautiful Lowell, Michigan. Yeah, yay Lowell. I'm really glad to see everyone here today. My name's Dan Brubaker. I'm the Chief Commissioner at the Michigan Supreme Court. And I'm here with another attorney from my office, Liza Moore, and we are going to provide you a brief background on the court itself and also the case in which you are going to observe the oral argument. But before I start, I need to do this. Could we get a big round of applause for all the educators from the Lowell Area School District today? So I had to do that because I had 4 kids who graduated from this very high school, and the last one was about 10 years ago. So I just wanted to report back that they all have jobs, they all have health insurance. None of them are living in my basement at the current time. So thanks, we did it. Seriously though, I have a great job. I get to go all over the state. We do the Court Community Connections program twice a year. A few years ago, we went to Traverse City, and I got to thank the school district that educated me. And today, I get to be here and thank this district, which is where my children receive their education. It really means a lot, and it also means a lot to me that the justices, who are my bosses, were willing to come here to Lowell today. So speaking of my bosses, let me tell you a little bit about them before they come out to hear the case being argued. We usually have 7 justices on the court. Right now we only have 6 because former Chief Justice Clement has stepped down and her vacancy has not yet been filled. First up is Justice Kavanaugh. In Michigan, the Chief Justice is elected by her fellow justices. It's not like the Supreme Court where the Chief Justice is appointed by the executive. I had the honor of working with her father, Michael Kavanaugh, when he was on the court. Justice Megan Kavanaugh grew up in East Lansing, and she joined the court in 2019 after spending many years in private practice as one of Michigan's top appellate attorneys. She's also the Supreme Court's liaison to the tribal courts. Next up is Justice Zara, who is the longest-serving justice. Justice Zara joined the court in 2011. He had been a circuit court judge in Wayne County. He was on the Court of Appeals, and he also teaches at the University of Detroit Mercy Law School. Next is Justice Bernstein, who joined the court in 2015. Prior to being elected to the court, Justice Bernstein headed up the Public Services Division of the Sam Bernstein Law Firm, and he advocated for disability rights. Although, as far as I know, he is the only blind justice in the entire nation. He's actually an avid runner and a marathoner, and we actually ran a race together a few years ago in Muskegon. Next is Justice Welch, who took the bench in 2021. She's our only justice from Grand Rapids. Before she became a justice, she practiced labor and employment law at a few large firms and opened her own practice. She also served on the East Grand Rapids Public Schools Board of Education. Justice Bolden is next. She joined the court in 2023. Before becoming a justice, she worked as she was a state representative in the Michigan House of Representatives. She worked extensively on criminal justice reform and legislation to protect the survivors of sexual violence. Justice Thomas is our newest justice. She joined the court just this year, earlier in 2025. Before becoming a justice, she was on the faculty at the University of Michigan Law School for over 20 years, and she was the co-founder and director of the law school's Juvenile Justice Clinic. So the way that it works in Michigan, the justices are elected to 8-year terms. It's not like the Supreme Court where they're appointed. They are elected, and their term is 8 years. As you can see, it's kind of like a pyramid, the way the appellate system works. So there's a lot of district and circuit courts, which are kind of the trial courts, which is where a lot of the action happens. And if you appeal from like one of the circuit courts and go up, you then go to the Michigan Court of Appeals. And the Michigan Court of Appeals has offices in a few areas of Lansing. When you appeal from the Michigan Court of Appeals, typically you then go to the Supreme Court, which usually hears cases at the Hall of Justice in Lansing. One thing to know about the Michigan Supreme Court, unlike the lower courts, there are very few instances where the court has to take a case. We call it applying for leave to appeal. People have to ask the court to take their case and hear argument, and we get about 1,400 to 1,600 applications for leave to appeal every year, and we only hear arguments in about 80 of those cases. In general, the justices are most interested in kind of the important cases that they think are going to have a significant impact on all 10 million of the people of the state of Michigan. So it is important to recognize here, like, this is not a trial court. That's not what's going on today. There's no juries in the Supreme Court. Instead, each party is attempting to persuade the justices that the Court of Appeals either got it right or got it wrong. They're arguing about what happened in the lower courts and what needs to happen now and whether it needs to be fixed or not. There's no objections. There's no witnesses. The attorneys don't jump up and object and interrupt each other, although the justices are free to ask questions, and believe me, they always do. Commissioner Liza Moore will now brief you a little bit on the case that's actually being heard today.
Thank you, Dan, and good morning, everyone. Today, we all have the honor of seeing the work of the Michigan Supreme Court in action. I'm here to share some background information about the case that the court is going to hear today, People v. Morris. This case is about sentencing, and in particular, the scoring of what is called offense variable 19. In June of 2021, police allegedly found methamphetamine in defendant's vehicle during a traffic stop. He was arrested, charged with possession of methamphetamine, and released on bond. In January of 2022, he was arrested on a different matter. He was taken to the county jail, and while in the jail booking area, police allegedly found some methamphetamine that fell out of his pocket, leading to additional charges. In July of 2022, defendant pleaded guilty to possession of methamphetamine arising from that 2021 traffic stop, and some other charges against him were dismissed. In August of 2022, the trial court sentenced defendant to 38 to 120 months in prison for that possession of methamphetamine conviction. As part of that sentencing process, the trial court scored the sentencing guidelines and calculated the recommended minimum sentencing range. And as part of those calculations, assessed 25 points for OV-19 arising from that 2022 jail booking incident. That leads us to the issue that the court is going to hear today, whether the trial court properly assessed 25 points for OV-19. Let's break this issue down a bit further. OV-19 is one of the variables that the trial courts consider when calculating a defendant's sentencing guidelines recommended minimum sentencing range. Trial courts use the sentencing guidelines when sentencing a defendant to an individualized sentence to reduce sentencing disparities and reduce unfairness. The sentencing guidelines are not mandatory, but a trial court must consider the minimum sentencing range from the guidelines and take that range into account when sentencing the defendant. Sentences must be proportionate to the seriousness of the circumstances surrounding the offense and the offender. Generally speaking, the sentencing guidelines apply to felonies for which the legislature has set an indeterminate minimum sentence and are calculated using different factors called variables that the legislature has set in statute. These variables consider the defendant's background or record and the offense. The prior record variables, called PRVs, consider the defendant's prior record and are assessed in all cases involving the sentencing guidelines. The offense variables, or OVs, consider the characteristics of the sentencing offense. Different sets of OVs are scored depending on which crime group the offense falls into. For example, possession of methamphetamine falls within the crimes involving a controlled substance crime group. Within each crime groups, there are different levels of seriousness, ranging from M2 and A down to H. Once all the prior record variables are scored and all the offense variables are scored, a defendant will have a total PRV and a total OV score. And those are inputted into something called the sentencing grid. This is an image of the sentencing grid for Class D offenses. You can see that there are different cells or boxes that correspond to a different total PRV or OV amount. So, the sentencing guidelines recommended minimum sentencing range is composed of those numbers that you see within the cell that corresponds to a defendant's total PRV and OV level. That means if a defendant has a lower, for example, OV level from perhaps a lower score for OV19, the defendant might fall within a different cell or block, resulting in a different recommended minimum sentencing guideline range. A defendant is entitled to be sentenced based on accurately scored guidelines and on reliance on accurate information. A trial court's factual findings regarding the offense variables is by a preponderance of the evidence. So let's dig into OV19, which is the variable at issue in this case. OV19 considers threats to the security of a penal institution or a court, or interference with the administration of justice, or interference with the rendering of emergency services. Courts assess 25 points for OV19 when an offender, by his or her conduct, threatened the security of a penal institution, meaning a prison or a jail or a court. In People v. Dixon, the court said that to assess 25 points, the court must find that 1, the defendant engaged in some conduct, and 2, that conduct threatened the security of a prison. In People v. Smith, the court said that OV19 contemplates post-offense conduct, meaning it could be something that happened after the criminal offense. So with all those principles in mind, let's turn back to what happened in this case. As I said a moment ago, defendant pleaded guilty to possession of methamphetamine. At the sentencing hearing, his defense counsel objected to the assessment of 25 points for OV19. The prosecutor argued that by bringing drugs into the jail during that 2022 booking incident, he threatened the security of the jail. Over defense counsel's objection, the trial court assessed 25 points for OV19, calculated the sentencing guidelines range, and used that range to sentence him to 38 to 120 months. Defendant filed an application for a leave to appeal, because this is a plea case, and at the Court of Appeals they granted leave, but then affirmed the trial court in an unpublished opinion. The Court of Appeals said that facilities used for booking are an important part of a detention facility, mentioned that OV19 applies to post-offense conduct, and said that drugs in jail threaten the security of a jail. Defendant filed an application for leave to appeal to the Michigan Supreme Court, which ordered oral argument on the application and directed the parties to address whether the trial court had properly assessed 25 points for OV19. That's the issue that the court is going to hear today. Students, as you're watching this oral argument today, consider how the decision in this case will affect the defendant and how it will affect future defendants in future cases involving OV19 and the sentencing guidelines. You're going to see the court hear oral argument from the defendant, the appellant, and from the prosecutor, the appellee. I hope that you have many questions and that you think of more questions as you are watching the oral argument today. There's going to be a time to ask those questions after the oral argument has concluded, so hang on to your questions until then. With that, let's proceed with the oral argument, and I'm going to turn things over to the court crier, Jeff Mills.
Justice and Justices of the Supreme Court of Michigan. All persons having business before this honorable court are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States, the state of Michigan, and this honorable court.
Good morning. My name is Nate Fowler, Superintendent of Lowell Area Schools. On behalf of Lowell Area School students, faculty, staff, the LAS Board of Education, it is my honor to welcome distinguished justices of the Michigan Supreme Court, honorable judges, local attorneys, community members, students and teachers from other area schools to the 31st edition of the Michigan Supreme Court's Court Community Connections program. We're thrilled to host this event at Lowell High School, where we have a long tradition of outstanding social studies instruction. We have a memorable day of learning as we witness the proceedings of the highest court in our state. It is now my honor to introduce Chief Judge Deborah L. McNabb, Chief Judge of the 17th Judicial Court here in Kent County. Judge McNabb.
Good morning. For those of you who are not from Kent County and have come in from elsewhere, welcome. We're very happy to have you here. I am Deborah McNabb. I'm the Chief Judge of the 17th Circuit Court here in Kent County. I'm one of those trial court judges that Dan Brubaker told you about and was showing on the pyramid. So it's my distinct honor to welcome you all to this unique opportunity to witness our judicial system in action. Today marks a significant occasion as we bring the Michigan Supreme Court directly to you. This isn't a mock trial or a simulation. You will be witnessing actual oral arguments in the case of People versus Curtis Allen Morris. The decisions made following these proceedings will have a real impact on real lives and will contribute to the body of law that guides our state. The Community Corrections Initiative was designed with a singular purpose: to open the doors of our justice system and make it accessible to you, our next generation of citizens, voters, and leaders. Too often, the judicial branch remains the least understood branch of government. We hope that by witnessing these oral arguments today, you'll gain valuable insight into how appellate courts function and their critical role in interpreting and applying our laws. I want to extend a special welcome to all of the students again. Your presence here demonstrates your commitment to education, civic educations particularly, and I encourage you to listen carefully, observe the proceedings, consider the arguments presented from both sides. The attorneys you'll hear today have spent countless hours preparing their cases, and the justices have thoroughly reviewed legal issues. In other words, they've all done their homework. I also wish to acknowledge our distinguished guests, local judges, and elected officials whose attendance underscores the importance of this program and the collaborative spirit of our legal community. As you observe today's proceedings, I invite you to consider several things. First, notice how the attorneys and justices engage with legal precedent, prior court decisions that guide our understanding of the law. Second, pay attention to how both sides frame their arguments and respond to questions from the bench. This dynamic exchange is at the heart of our adversarial legal system. Finally, consider how the constitutional principles that form the foundation of our democracy are applied to this case's specific circumstances. After the oral arguments, you'll have the opportunity to ask questions of the attorneys and the justices. I encourage you to take advantage of this rare chance to engage directly with legal professionals about the case and the judicial process. The proceedings that you witness here today represent the culmination of years of legal work, from the initial charges through the trial court to the Court of Appeals and now to the highest court in Michigan. But more importantly, they represent our ongoing commitment to transparency, education, and the belief that justice is best served when citizens understand and engage with their legal system. Thank you for your attention. And I understand that I believe we're going to have a bit of a concert again. Am I correct? Okay. So I would welcome the band.
Okay. Can everyone hear me? Am I on?
Right now.
Okay. Wonderful. Good morning. Thank you for that. That was amazing. And good morning, everyone. Welcome to the 31st Court Community Connections program. On behalf of my colleagues on the Michigan Supreme Court, we're thrilled to be here at Lowell High School to continue this important tradition of bringing the court directly into communities across our great state. Before we dive into today's case, I want to extend my thanks to our hosts, the students, and the educators who have joined us today. We are especially pleased to welcome students from Lowell High School, Cedar Springs High School, Coopersville High School, Grand Rapids Catholic Central, Riley Street Middle School, Saranac High School, and Sparta High School. So welcome. This is a very special occasion for a couple of reasons. Not only does today mark the 31st Court Community Connections event, which is a program dedicated to building public trust and improving understanding of the judicial system by engaging directly with Michigan's youth and communities, but today also marks my first time participating in this program as Chief Justice. And one other first is important to note. This is the first Court Community Connections since Lowell's own Dan Brubaker was named to the post of Michigan Supreme Court Chief Operating Officer. Dan was recently chosen for the job after more than 2 decades in the Commissioner's office, and you got to meet Dan in a briefing earlier. You'll get to talk to him later after we are done hearing the case. And so you will no doubt walk away knowing how lucky you are to have him, how we are to have him leading our team. So before I recognize our local hosts, I do want to recognize someone else who has been with the Michigan Supreme Court and the Court of Appeals for 40 years, and that is Michigan Supreme Court Clerk and Chief of Staff Larry Royster. Larry is retiring later this year, so I definitely wanted to take the opportunity to publicly thank him for his service to this court and to the people of this state. So thank you very much, Larry. Now I'd like to present a couple of resolutions recognizing and thanking our hosts this morning. First, I would like to present a resolution to Lowell High School. Superintendent Nate Fowler, would you please come forward to accept the resolution on behalf of Lowell High School and these awesome students here today. Has welcomed the court with open arms, and the dedication of your faculty, staff, and administration has been instrumental in ensuring this experience was impactful and meaningful to your students. So thank you for that. Next, we would like to recognize the 17th Circuit Court, Kent County, for its steadfast commitment to community engagement and public service. Chief Judge Deborah McNabb, would you please come forward and accept a resolution as well? Judges and staff of the 17th Circuit Court played a critical role in supporting today's program and in consistently demonstrating how local courts are promoting public trust in the judiciary. Okay, a few other recognitions. The Kent County and Ionia County judges, along with local dignitaries and members of the bar. Kent County Clerk Register of Deeds, Lisa Posthumous Lyons. This is her alma mater, and all of her kids are red arrows. Special thanks to all the officers who keep us safe and secure, including the Michigan Supreme Court, security personnel, Michigan State Police, Kent County Sheriff's Office, Lowell Police Department, and School Resource Officer Todd Summerhays. I also want to thank the Lowell High School Fusion Rock Orchestra for their incredible performance earlier today. What a really cool way. We don't typically have a rock orchestra open court on a normal day, but today was a special occasion, so thank you for that. Also want to recognize Chief Operating Officer Dan Brubaker and Commissioner Liza Moore, who will lead today's case briefing and debriefing discussions with the students. And a big thank you to Zachary Stempian and Chris Cavella, counsel for the parties in today's case, People versus Curtis Allen Morris, for generously agreeing to participate not only in oral arguments, but in the student question and answer program afterwards. So thank you for that. So before we proceed and call the case, I wanted to share two key messages. First, we are here today because community engagement builds trust. Trust is the judiciary's most valuable currency, and events like Court Community Connections helps foster accessibility, fairness, and confidence in the rule of law. Our commitment to inclusivity, diversity, and greater access to justice is a reflection of our mission to ensure every Michigander has faith in their courts. Second, while we continue to embrace new ways to make our courts more accessible, one thing remains unchanged: our unwavering commitment to judicial independence, the rule of law, and serving the people of Michigan. So a few housekeeping notes before we move forward. Once oral arguments begin, we kindly ask that you refrain from taking photos, with the exception of credentialed media. There will be opportunities for photos after the case during the reception later today. Please silence and power down all the cell phones during arguments. And after arguments conclude and my colleagues and I leave the stage, please remain in your seats for the student debriefing with Dan Brubaker and the attorneys. So oral arguments are a critical component of the appellate decision-making process. That the questions we ask and the arguments we hear today will help us craft a decision that clarifies and interprets Michigan law for the future. Students, you've been briefed on the facts and legal issues in People versus Curtis Allen Morris, and I encourage you to listen closely to the arguments and think critically about the questions that we pose. After the case concludes and we issue a decision, you'll have an opportunity to review our decision and decide for yourselves whether you agree with our reasoning or would have ruled differently. My hope is that today's experience deepens your understanding of the rule of law and inspires you to consider careers in public service or law. And for those of you interested in taking that next step, I'm excited. I wanted to share an opportunity that is designed just for that. Exploring careers in the law for high school students is a unique summer experience for rising 10th graders through new graduates who are curious about legal careers. Participants argue a case as if before the Supreme Court and work closely with law students, attorneys, court staff, and members of the judiciary to prepare their case. This program is held in Lansing, July 14th through the 18th at the Hall of Justice, and in Detroit on July 25th at the Third Circuit Court. You can find more information in the event program that you received today. We are honored to have you here and excited to share this day with you. And with that, I will now call the case. So, calling docket number 166566, People of the State of Michigan versus Curtis Allen Morris. Counsel, you may begin your argument. You have 2 minutes of a fire-free zone, which you may waive, and you may reserve some time for rebuttal. If you do, we just ask that you keep track of it yourself. But please begin whenever you're ready.
Your Honor, am I supposed to hit these buttons here, or they go by themselves?
No.
Okay.
Our car will handle the buttons and the lights for you. But if you want to reserve a couple minutes, just let us know and he can help keep track.
Thank you. Good morning, Justices. May it please the Court. I am Charles Cavello. I am attorney for the appellant Curtis Morris. This court has held in applying a statute, the statute is to be given a reasonable and common sense reading, and that penal statutes are to be strictly construed, and any ambiguity is to be resolved in favor of leniency. The Court of Appeals did not follow those principles in their decision. First, to score my client, Mr. Morris, with OV-19, a court must find, quote, by his conduct, unquote, he threatened the security of a penal institution. The dictionary definition of conduct is personal behavior or way of acting. A reasonable and common sense understanding of conduct is that it is some kind of voluntary action. But Mr. Morris's bringing or being found with meth in the jail was not voluntary on his part. He had been arrested, handcuffed, put in the back of a police vehicle, and brought to the jail. If he knew he was going to be arrested that day, he wouldn't have had meth in his pocket, if he did have meth in his pocket. The Court of Appeals wrote, quote, defendant was being placed in jail for a separate offense, unquote. Being placed in jail means that...
That's just the end of your free fire.
Oh, thank you, Your Honor.
Yeah.
Means that someone, being placed in jail means that someone else was putting Mr. Morris in jail. A reasonable, common sense analysis of the situation is that the defendant was arrested and brought to the jail involuntarily without a chance to divest himself of any methamphetamine or any other dangerous item. And therefore,
Counsel,
he did not...
would you agree that there are circumstances where someone is in the booking area and it could be a threat? If they had drugs, are there circumstances where it could be a threat to the penal institution?
Your Honor, it's a little hard to hear you because
Sorry, it's sort of echoing. I'm trying to back this up. Would you agree that there are circumstances where a defendant could be in a booking area of a jail and that it still could be a threat to a penal institution?
I do, Your Honor.
So what would that look like?
Well, if the person came in with a substance that is dangerous, generally dangerous to everybody, say, I'm trying to think of what it was, anthrax. If a person came in with a bag of anthrax, if anybody touched it, that's a danger to the people working at the jail. So that would be one example of something that I would say is a threat to the jail.
So is for your analysis, for us to agree with you, there's sort of an element of voluntary versus involuntary. Is that the distinction?
On this first argument, yes. Yes.
Okay.
And with the results of that?
I'm saying the statute requires a course of conduct. It requires that. And so the question is that his conduct if he's dragged into the jail?
So would that, under that logic then, would that be carving out a giant exception for every detainee? Anybody, which is probably most people, who are brought into the booking area of a jail are brought in voluntarily. So this would be a huge exception if it has to be voluntarily brought in under that logic. So no
Yes, Your Honor.
detainee could ever meet that standard.
Yes, I do believe that the statute should be read that way.
Okay.
Because again, they put course of conduct in there for a reason, and I think the reason is it has to be deliberate.
So is there a distinction between being brought into the jail booking and being brought in, the voluntary conduct being brought into the booking with drugs? In some aspects, and I understand your client's position that he wasn't aware of it, but that he voluntarily had the drugs on him, even if he wasn't voluntarily going into prison or into jail. So why would we not look at the fact that he voluntarily had drugs on his person as the voluntary conduct?
Well, I understand that, and I've seen that argued in cases on this issue, but again, I'm asking what I think this court has held in the past is we're going to apply a reasonable and common sense analysis to this situation, and I believe the only reasonable common sense analysis is if you're brought into the jail involuntarily and you happen to have something on you, it doesn't have to be meth, it could be a screwdriver in your pocket. They could say, well, that's dangerous, that's a weapon. You know, we're gonna score you for OV-19.
But going to your screwdriver analysis, eventually at some point as they go through the booking process, an inventory is done of what's on their person. And if the screwdriver is found then, you, I think, have a better argument that there was no conduct on the part of the defendant. It was in his pocket, it was removed in the booking process. But couldn't the conduct be, if for example, in your scenario, whether through neglect or intentionally, he decided, I shouldn't have this screwdriver on me, I'm gonna drop it in my chair so I don't have it through the booking process. Now I understand you're saying he didn't intentionally drop it, but still at some point, it's conduct to either permit it to fall off your person or intentionally do so. Couldn't that be the conduct that's required under OB-19? Because once it's on the floor in the jail, even though it's at the booking area, there are going to be other people who could pick it up, take the drug, who knows what the effect of the drug is on them, and it creates a dangerous situation in this building with this jail and booking area.
Judge Zara, I think all of you, if you're connected, and I have to listen to you from that, it's very hard. I get the gist of what you're saying, but I'm not getting all the details of what you're asking.
So the conduct,
Right.
if he just had it on his person, went through the booking process, and then eventually when you are about to be put into the jail and you are inventoried and everything on your person is removed and you're given different clothes to wear and it's discovered then, I feel more sympathy for there's no conduct. What did he do? But when the drugs fall off the person in the jail, and then we're going to assume the booking area is in the jail. I know you make the argument that it's not. Isn't that sufficient conduct to create circumstances to support OV-19? Because now it's on the floor, for whatever reason, whether it was intentional or by neglect, it's on the floor where other people going through the process might find it, take the drugs. Meth affects people differently. They could, all of a sudden decide to start fighting with the security police officers in the area. So the fact that it's off of his person in the booking area, couldn't that be conduct under OV-19?
Well, Your Honor, I would, I guess I wouldn't agree with, personally, I don't agree with that analysis in light of the way the statute is written.
If it was, now I understand there's a question of whether it was by neglect or intentional. If the act was intentional, oh my gosh, I realize I've got meth here, I'm going to drop it on the floor. Would that be enough for OV-19?
I don't believe so, Your Honor. He's put in this situation. He's taken off the street and handcuffed. I think you have to think of this from his point of view. If they, he knows he's going to be, well, if this happened, he never admitted that it was just meth. But any person in that situation is going to try to drop something if they don't want to get caught with it red-handed on their person. But is that the kind of conduct you want to apply this statute?
So your argument basically is that's the opposite of a threat to the penal institution. You're trying to get rid of it.
Exactly.
Okay.
But again, he's put in this situation that he didn't volunteer for. He didn't plan to show up at the jail with meth. He was dragged off the street, and he was handcuffed in the back of a police cruiser. He's not going to be able to get rid of anything. So I guess his choices would be, well, does he tell him or does he drop it or something? And I think that's maybe the situation he was in.
Or does nothing.
If he does nothing, they're going to find it on him and charge him with meth possession.
What what do we do with the fact that he did disclose other drugs? He did disclose some Suboxone, right? That was in his wallet.
Yeah. Well, again, he wasn't planning to go to the jail, so the way I read the statute, it wouldn't apply. Even if he says he has it, or it falls off him, or they find it on him, all of those circumstances, my focus and the focus I wish you would accept for the state of Michigan is that if a person is arrested and brought to the jail, what happens in that booking area, that can't be called their conduct.
So would you agree that somebody's conduct outside of the jail could threaten the security of a penal institution?
You could have people in the parking lot shooting mortars carrying drugs into the jail.
Phone in a bomb threat.
Right. Anything.
So that is your position that whether it's inside or outside is really not relevant, or does the location of it play into the analysis of whether or not it was a threat, whether or not it was voluntary?
The location is important because the Court of Appeals made an issue of it. I mean, they defined jail for you, as if you didn't know what a jail was. That's the purpose of that area, is to intercept harmful material. And they said, well, it's a threat to the people in that area. Again, I don't think common sense and reason lead you to that conclusion. Those people that's what they're there for. That's what that room is for, to intercept anything dangerous from getting back into the housing area. And that would be my second argument, that processing people into jail is a routine procedure.
But you would agree that there are, I think in response to Justice Welch's question, that there are certain items that could present a danger in the booking area.
Yes, by their very nature, as I said, the anthrax would definitely, that's a threat to everybody. You could have a ticking time bomb on you, I suppose, or, there's things you could have that would threaten people, definitely. But this is a case of, meth is fairly prevalent around here, everywhere, and to me, it's a routine situation, and the rule of law should be with routine, common things that people are picked up with. Say, for example, a person buys some marijuana at a dispensary, and they get arrested on the street and handcuffed and brought in, and they have a big bag of marijuana in their pocket. Are we going to say that's a threat to the jail?
So I just want to make sure I understand. Take the meth out, put a little bit of anthrax in the back pocket, left the house with it in the morning, doesn't expect to get arrested,
Right.
gets arrested,
Yep.
officer does a search, doesn't discover it, brings him into booking. Can you get OV 19 points for that?
Yes.
But you can't for the meth.
Yes, because like a bomb, anthrax is inherently dangerous. It's dangerous to everybody at all times.
What about heroin?
I would not put heroin in a dangerous to everybody at all times. A bag of heroin, a bag of meth, a bag of marijuana, those are, I know you folks do as much criminal work as I do. That's routine for police to find that stuff all the time. They're always finding it.
But don't you think, whether it be meth, marijuana, heroin, fentanyl, whatever it may be, in a jail has the potential to threaten the security of it. It's not allowed in the jail.
Exactly, sure, I understand
There
that.
are consequences to people possessing it. So why is it, and in Dixon, I think we recognize that there are certain items that can be inherently dangerous and inherently threaten the safety of a penal institution. Why are drugs not that? Or are you drawing the line between type of drug based on how sort of commonly it's possessed?
If he had gotten through intake and into the housing unit with the drugs, OV-19 would apply, in my opinion. But the fact that I think you have to, make a reasonable, common sense analysis of the situation. He's in processing. He hasn't been admitted to the,
So does your case rise or fall on whether processing is considered part of the jail?
that would be my second argument,
It
yes.
doesn't rise or fall on that. You're saying, first of all, there's no dangerous substance. Meth is not dangerous, heroin's not dangerous, anthrax is, fentanyl not so sure, or maybe that's not dangerous. It doesn't rise or fall on whether this is housing. That's your second argument. Your first argument is this substance just isn't dangerous.
No, my first argument is this, it's not conduct when a person is picked up off the street and brought to the jail.
To me, that's the third argument to me.
Oh, okay, well,
Okay. Your time has expired. Thank you.
Better than I, or?
You did not say anything.
All right, thank you.
Thanks.
Good morning, Your Honors. Zachary Sempian on behalf of the state of Michigan. It is an honor to be here. May it please the court. In this case, OV-19 was properly scored in consideration of the purpose of the offense variables and the facts of this case. Not long ago, this court in Dixon reiterated that each OV reflects a particular factor that the legislature believed to be important in determining an appropriate sentence. We all know that the purpose of the guidelines are to eliminate disparity and to create a more uniform approach in determining an appropriate sentence. I offer to the court today that the application of the non-binding sentencing guidelines in this case did exactly that. In this matter, OV-19 was scored based upon post-offense conduct of bringing methamphetamine into the Branch County Jail. This court long ago in People v. Smith indicated that OV-19 almost always contemplates post-offense conduct. And frankly, that makes sense. A court sentencing a defendant wants to sentence a defendant based upon all the circumstances surrounding them, not just the moment in time when the crime was committed. By scoring conduct such as that found in this case within OV-19, it creates a uniform approach to post-offense conduct to a defendant's sentencing, which certainly advances the purposes of the Michigan sentencing guideline. That opposed to much greater discretion, which can be found under MCL 777.34, to exceed the guidelines if the conduct is not otherwise considered within the guidelines. In this case, OV-19 functioned exactly how the legislature intended it to. It assigned a set point value to a defendant's conduct in lieu of less restrained consideration by the trial court outside the parameters of the guideline. Now, I certainly understand that the court is looking to further define what conduct means in regards to OV-19. And the court defined what the test is for OV-19 in People v. Dixon, which was mentioned a couple moments ago. And essentially there's a two-part test, that the defendant engaged in conduct and that that conduct threatened the security of the penal institution.
Counsel, I just have a question.
Yes, sir.
Explain to the court, if you could, why is it that these drugs pose a danger? We've heard the distinction between arsenic and things of that nature, which is understandable that could pose a real danger. But what is it about these specific drugs or these specific products that is such a danger to the institution?
Yes, it's my belief that methamphetamine is one of the most dangerous drugs that we have on the streets currently. Methamphetamine mixed with other drugs certainly reduces or causes overdoses. It causes erratic behavior. It causes violent behavior. In fact, methamphetamine is so dangerous that the legislature chose to make it the only drug in the state of Michigan that, based upon the drug alone, is a 10-year felony. Every other drug has a weight component to it. So methamphetamine, regardless of if you have a gram or 10 grams, it's a 10-year felony. In my experience, certainly methamphetamine is a dangerous substance that creates behavior that is unpredictable, dangerous, and violent to everybody else around them.
Counselor, if it was cannabis, would a defendant have been charged with OV-19, or should a defendant have been charged with OV-19?
So I think cannabis is certainly an evolving substance. Obviously in the state of Michigan, it's a legal substance now. I think cannabis goes more in line to what we would view alcohol as. And there may need to be additional facts in regards to cannabis of whether or not that truly threatened the security of the penal institution. That compared to a substance such as methamphetamine, which has no medicinal purpose, it has no legal purpose. And I direct the court back to some of the language that we talked about in Dixon, where the court pointed out that a cell phone is legal for people to possess outside the penal institution part of it. Cannabis is legal for somebody to possess outside of the jail. Methamphetamine is illegal for anybody to possess. So certainly I think cannabis would be a different analysis, but I think at the end of the day, when we look at the facts of this case, methamphetamine is certainly something that inherently would be dangerous within the confines of a jail.
Are you familiar with the recent Court of Appeals case of People v. Hines?
I am, Your Honor, yes.
What would you have to say about that case?
To be frank with the court, I find it unfortunate, and I kind of cite back to People v. Ward, Justice Young's opinion, that it is my opinion that when we look at defendants' behavior and defendants' conduct, Michigan criminal law should never be in a place where we excuse the conduct because it puts them in an uncomfortable situation. I think it's been alluded to a couple of times today that, the defendant voluntarily at some point in time possessed these controlled substances. They then, yes, they were arrested. They were brought to the jail, presumably involuntarily. I do not dispute that. But the fact that they now have to choose between an undesirable result doesn't mean that the court cannot consider OV-19 in the conduct within the jail. And I think as a bigger picture, I think it's important that we remember that we're talking about conduct and we're talking about the offense variables in this case.
So you would agree that, if defendant had, as part of the booking process, said, oh, I've got some drugs on me, then no problem, not scored?
I 100% agree to that. And actually, as kind of an offer of the court, I had that same scenario Monday in a sentencing, and OV-19 was not scored on that. And I think that goes back to what we're trying to define conduct as. When we look at conduct, the conduct of either having methamphetamine fall out of your pocket or throwing methamphetamine on the floor, however it got there, that is conduct that threatens the security of the jail. Conduct of saying, hey, I have methamphetamine on me, it's in my pocket, that's conduct that does not threaten the security of the jail because now we're appropriately divesting ourselves of that controlled substance.
So
There's a distinction
there.
there.
Scored, but could somebody, even if they disclosed it, be charged with possession?
Potentially, they could be.
Disclosing that? So, as noted in Hines, you're saying it's an uncomfortable choice or result, but it's really a choice between disclosing it and risking the offense variable, or choosing, it's not sort of a choice, it's a protected constitutional right against self-incrimination. It puts somebody, this isn't just sort of, well, you could have chosen differently, right? This is a right that our Constitution protects to not self-incriminate.
Absolutely, and I think there's 2 points on that. One, when we're looking at offense variables in and of themselves, we're talking about scoring a non-binding tool that is used to come up with an ideally proportional sentence. We're not talking about necessarily criminal liability within the confines of the offense variables. So a defendant may have to choose, am I going to divest myself of that or potentially have OV-19? However, I would say realistically, and again, applying kind of a common sense approach to this, there are very few defendants in this world that are going to go into that situation going, if I give up these drugs, I'm not going to be scored OV-19. If I do, I'm going to be scored OV-19. To me, that's not the consideration. The consideration by defendants are, am I going to get caught with this or not? Am I going to get in trouble with this or not? Or potentially, can I get this back into the jail or not? And certainly making those sort of decisions, I'm not sure if something that we should encourage. And I do feel that if the case law comes out and the precedent comes out the way that it's being asked, that any defendant that brings drugs into the jail, as long as they don't get them past booking, OV-19 will not be scored. To me, that has the opposite effect of encouraging individuals to try to divest themselves of controlled substance in an inappropriate manner.
Counselor, you mentioned People versus Ward, and in that concurrence, Justice Young really emphasized that the person knowingly carried these narcotics into the jail. And brother counselor has talked about the sort of how Mr. Morris ended up in the facility. So that sort of question about his conduct in getting there. So I'd like you to address that.
Yes, so People v. Ward, the way that I understand the facts was the defendant went to the Michigan State Police Post, I believe, to meet and have some sort of an interview. That was kind of a ruse because they were going to arrest him on open warrants. They arrested him. He didn't disclose that he had any other controlled substances on him, so they took him to the jail, at which point they then found the controlled substances. So within that confines, certainly it was a voluntary behavior of him to go to the police station with the drugs on him. Certainly in this case is a little bit factually different. And it's factually different in the sense that the defendant was going about his business when he was arrested on a parole hold, at which point there was some resisting and obstructing, so there was that charge, and then obviously the conduct later. So certainly when he woke up that morning, did he go, I'm going to go to jail today? He didn't. but he still had the voluntary thought to have at that point in time Suboxone, as this court already discussed, was disclosed, and then methamphetamine as well, which was found falling from his belongings. So I do think that there was still more purposeful conduct from him to have that controlled substance on him. And to me, it would still be appropriately within the confines of OV-19.
Does he have to purposely intend to have the substance on him at the facility? Or
I don't-
in a way that threatens? So if we look at the language of the provision, right? Conduct that threatens.
Yeah, so again, going to the test that was enunciated in Dixon. So does he have to intend to threaten the security of the jail? My position on that would be no, because the OV is written as his conduct threatened the security of the jail. You can engage in conduct unintentionally that still creates that threat. And again, when we're looking at the offense variables, we're looking at creating a proportional sentence. There is an avenue here to alleviate some of these concerns that if you have a defendant that's engaging in behavior that threatens the security of the jail, results in 25 points, but it's more minimal. The court understands why there's that behavior. The court understands why they did that. The court can deviate from the guidelines and not have any issue with that. The court can minimize the effects of that within the sentencing guideline. So when we're looking at...
You said in your opening, and I think it's probably correct, that the purpose of OVs, right, is to eliminate a disparity. And we're looking at what the legislature's intent was in assessing 25 points. And what do we make of the fact that the legislature put, you know, a arrestee having meth fall out of his pocket in the booking area on par with a scoring of 25 points for supporting terrorism under OV-20, leaving a victim with life-threatening or permanently incapacitating injury under OV-3, and on the other side, even using force or a threat of force to interfere with the administration of justice is only 15 points. So how do we, recognizing that it's to try and eliminate disparity and we're supposed to be viewing what the legislature intended for that, why shouldn't we look at where this sort of falls in relation to those comparable conduct that counts 25 points and conduct that counts for less?
Yeah, and I can certainly appreciate the obvious differences in those behaviors. So obviously terrorism is something that would be much more significant than introducing controlled substances within a jail facility or a prison facility. You know, unfortunately, I'm not really in a position to tell you why the legislature phrased those in that way, shape, or form. You know, what I can say is when we're looking at the offense variables in total and we're looking at the points assigned, and I've never been a judge, I'm not sure 100% what the thought process is of a judge when they're sentencing, but certainly if somebody is misbehaving within a prison context or a jail context or the booking context or in the court context, that would be something that would show that they have the inability to follow direction and inability to follow the law. So certainly I could see assigning a higher point value to that. Whether or not that should be the same as terrorism, I can certainly appreciate that. The differences between the two, I don't really have a good answer for you on that.
Counsel, what do we do about the sort of, based on your argument, that you have this difference between someone who's during arrest, the drug, you know, there's a frisk and they find the drugs, arrest the person, bring them to the jail, no OV-19 problem, versus didn't find it in the jail, part of the booking process, find the drugs. Why is there a difference?
Yeah, so the difference is there's behavior that occurs during that frisk on the roadside that certainly could prevent the finding of controlled substances. And again, I'm speaking generally here because we do not have those facts in this case in front of the court. But we've had defendants in the past in my career who have moved drugs from one pocket to another while they're being frisked, that have had internal and external pockets so they can move them from the internal to the external, or they have them concealed somewhere else upon their body that they're not going to be able to find. We have videos of inmates being booked into the Branch County Jail that are removing substances from crevices of their person and different things. We've also had scenarios, you know, if we're speaking about whether or not the booking area is part of the jail. Recently, we had a case where an inmate threw methamphetamine on the floor and the trustees who cleaned the booking area found the methamphetamine on the floor. So certainly, because the police officers did not find the controlled substance, to me, that's not the end-all be-all of OV-19. Police officers, when they're on the road, are tasked with the very difficult task of not only arresting somebody, securing them, getting them from the scene. There's many things that could occur on the road that might result in a more shorter frisk on the scene. If it's the weather, if it's, you know, somebody around there that's creating a disturbance, if it's a need to get somebody back, if the defendant's unruly. So when I read in People v. Hines that we talk about that it might encourage police officers to not search a defendant thoroughly on the road in hopes of getting additional charges into the jail, I pose two things to that. One, in my experience with law enforcement officers, that's never the case. Law enforcement officers are not worried about OV-19. They're not worried about finding more charges. They're not worried about trapping defendants. They're worried about getting somebody in custody and getting them to the spot that they need to be. The second thing on that would be, is it creates this idea that somehow possessing contraband in a jail, which is a 5-year felony, is more significant than possessing methamphetamine on the road, which is a 10-year felony. So if a police officer found methamphetamine on a subject on the road, it's the same penalty as if he actually found it within the jail. So when I read Hines, I was a little taken aback by the idea that we would have this thought process that law enforcement would create this scenario. I think that would be very untenable, and I think it would be a very uncommon situation.
So is there any significance, so my understanding from the witness interview is that as Mr. Morris is folding up his pants, something fell out of the pocket, right?
Yep.
Or these drugs fell out of the pocket. I'm wondering if the pants were never going into the jail, correct? Like if the drugs had stayed in his pocket, he is literally disgorging them because the pants are not going with him. So I wonder, like, is that relevant at all to this idea of whether or not it actually threatens the safety of the penal institution? If he had just taken them all out as they're asking and put it all out on the mat, but he's literally, if it's in his pants and he's turning over his pants, not putting them back on to go back into the jail. So why is that not?
Yeah, so I think in our case, the facts as indicated in the police report and the PSI were, as the defendant was folding up his pants, a substance fell from his pants area. Again, we've had scenarios where individuals have thrown it as they're doing that because they're able finally to get it out of the view of the corrections officer. Certainly if the controlled substances stayed within the pant area, one, they would search those pants again when they go to put them in lockup, so they would probably still find it. And at that point in time, it's not going onto the ground. I think we're assuming for a moment, factually, that the substance did just by happenstance come out of the pocket. The trial court judge in this case did hear that statement of the defendant going, well, I'm not saying it fell out of my pocket, but I'm saying I pointed it out.
If it had stayed in his pocket, could he be scored? And like you said, later they'll search his pants and they find it. Would he be scored that?
If it stays in his pants, I would say at that point in time, most likely not, unless if he's engaging in other mischievous behavior to try to conceal that and hide that. And again, we've had scenarios with that in the past where we've not scored OV-19 similar to that.
So is that sort of just a discretionary decision?
I wouldn't say it's discretionary. I think it's looking at the facts surrounding the circumstances of the case and whether or not his conduct did or did not threaten the security of the jail. Yeah, the context matters. Correct, and that's where I go back to the example that I used earlier about an individual that comes in and they go, yes, I have meth in my pocket. Certainly they're within the confines of the jail. Certainly that's still a dangerous substance within the confines of the jail. But their behavior at that point in time is not creating a threat. It's minimizing the threat by saying, I have this on my person. You need to take this away from me. That minimizes, and actually OV-19 directly talks about a defendant that does not engage in conduct that threatens the security of the penal institution. You get 0 points. So I would argue in that scenario they're not threatening him.
Thank you very much.
You're welcome.
The case will be submitted.
Thank you, Your Honors.
It's going to take just a second. We need to get situated up at the table, and then we will begin the debriefing. hear me? Good morning. Can you hear me? Okay. I want to start by saying that arguing before any court can be a little bit nerve-wracking, and arguing before the Michigan Supreme Court can, even under normal circumstances, can be particularly stressful. But arguing before the Michigan Supreme Court with a room full of judges and students at your back is above and beyond the call of duty. So please give a round of applause to our attorneys here today. I also want to reiterate what Chief Justice Kavanaugh said on behalf of the Michigan Supreme Court. We are very thankful to the Lowell School District for hosting us and for everyone in the community who chose to attend. It's really been a pleasure for me to be here in this auditorium where I watched my kids in band and orchestra and musicals, and I appreciate the opportunity to show the justices the warmth and the charm of Lowell. One of the things that I enjoy about my job is that I usually get to sit with the justices, both during their weekly conferences and then after oral arguments. And I sit with them while they discuss the case, and I get to hear their conversations. And that's what's happening now. The justices are meeting, they're going over the briefs that were filed in the case, they'll talk about the questions and answers from oral argument, and they'll just kind of pick each other's brains about what they think should happen. At this point, they have a whole range of options open to them. They could simply deny leave and let the lower court decision stand. They could reverse the Court of Appeals. They could affirm the Court of Appeals. Or they could decide that they actually need more fully developed argument and grant leave to appeal. If they decide to do something simple, that decision could come out in a matter of weeks. If they decide to do an opinion, it could be months. You know, and at this point, I have no idea what they're going to do. But I do know that all of the justices have given a lot of time and attention to looking at the law and the facts of this case, as well as the parties' arguments. And they are having a civil discussion that includes listening to each other carefully and thoughtfully considering each person's point of view. So we now have about 25 minutes for questions before we head to the reception. I have a few questions that I can ask if the room goes silent, but I'm really hoping that we don't need to do that. Those of us who work on this Court Community Connections and put it together we really want to know what you thought about what you heard here today. We want to know what your thinking is, and we want to hear your questions. So please don't be shy. If there's any question you have, we would like you to ask it. There are some microphones set up, so what we're going to do is please go up to the nearest microphone to ask a question. And I think I'll be able to figure out who goes next, so I'll be pointing. The microphones in the back are a little dark, so just jump in if you need to ask a question and you think it's your turn. And I realize that we have a lot of community members here as well as students, so I would ask that the students have the opportunity to go first, as this is primarily an educational event. To kick things off, we'll start with this. And when we're in court, the appellant typically goes first, so I'll start with defense counsel. Could you please introduce yourself and just tell us a little bit about what you do in your practice of the law?
Hello. Is that working? Yeah, okay, hi. Good morning, everybody. I'm Charles Cavello. I am an appellate defense attorney. I have done many different types of law in my life, but now I'm restricting myself only to doing appellate cases like this.
Okay, and appellee.
I'm Zach Stempian. I'm the Branch County prosecuting attorney. I've been the prosecuting attorney now for about 6.5 years. So I handle pretty much all criminal law. We also do some child neglect law stuff as well. And I do some appellate law on the side. So this is actually my first time being in front of the Supreme Court. I've done about a dozen or so Court of Appeals cases. So it was certainly a different experience.
Okay, and with that, it's open for questions. Okay, we'll start right here.
What is legally considered jail in these instances? Like, I remember they said, like, you can't bring things into jail, but what is legally considered jail? Like,
Can you repeat
I guess
that
I
one
could
more time?
clarify.
Yeah, sorry, we're having trouble hearing you.
What parts of the building are legally considered jail? Like, would the parking lot be considered part of the jail?
I got the question. So the question was what parts of the jail are considered actually parts of the jail? That is one part that's actually somewhat up in question in this case, is whether or not the booking area is part of the overall jail facilities. So hopefully nobody's been in jail, and if not, I'll give you kind of the overview of it. So when you get arrested, the patrol car would take you into an area that's called the Sally Port. So it's like a garage area. That's where you would get out. They then take you into what's called the booking area. At the booking area is where they get like your name and all your information, and they also have you change into jail clothing at that point in time. The allegations in this case are that it was in that booking area that the controlled substances fell out. Then after you're booked, then you go back then into holding, which would be back into the jail part, the actual cell part of the jail. So all of that area is kind of locked down. You can only get in there if you are supposed to be in there. But there's certainly different levels of that part. Does that answer your question?
Yes, it does. Thank you.
You're welcome.
We'll go over here to my left.
All right, hi. I was just wondering, you mentioned that this was your first time in front of the Supreme Court, and not sure how many times you've been up here, but when you guys got called to kind of go in front of the Supreme Court, was that like a really cool thing? Like, yeah, I'm gonna be in front of the Supreme Court. Or is it more like a, yikes, I gotta go in front of the, the top dogs?
That's a good question. So my view on it was that's cool. So it's always been a career goal of mine to argue in front of the Michigan Supreme Court, and maybe someday the United States Supreme Court, which is even, in lack of a better term, a higher court. So I thought it was very cool. I thought it was a great opportunity, and I've loved every bit of it.
Awesome.
When you get a call like that, yeah, it's flattering and it's interesting, and there's sort of an initial rush of enthusiasm, but the reality is it's 40 hours more work, and you got to find time for it. And the past week, it's a lot of work. I got other things to do, so it's kind of a mixed blessing. Although this whole event was very rewarding today. So.
Yeah. Well, thank you.
Thank you.
Thank you.
Go to the back, my right side. Yep.
My name is Eamon. I'm an eighth grader at Northern Hills Middle School. This is my question. Was there a large enough dosage to be ingested by others and make others irrationally act?
Yeah, so the question was the quantity of methamphetamine that was found. I believe off the top of my head it was 0.33 grams, which would be enough to be ingested by somebody and consumed in some way, shape, or form.
Thank you.
You're welcome.
Go to the back on my left.
Hello, I'm Roger Jean from senior of Lowell High School. So my question was, in the wording as you described it for OV-19, is that the behavior of the defendant had to threaten the penal system location, correct? So what the defendant's, his meth that he had on his possession would not have actively been brought into the system as I understand it. So was it still considered threatening the system even if nothing were to happen?
So it kind of got a little muddled there at the end, but the way I understand the question is the defendant got brought into the jail. Can you kind of repeat the very end part of that?
So because the meth that he had on him would not have been would not have been brought into the jail system itself, would it still be considered threatening the penal system?
Okay. And again, that's actually one of the main issues of the case is because the controlled substance methamphetamine was found within the booking area and never got into general holding part of the jail, did it actually threaten the security? My position is going to be yes, it did, for the reasons that I stated here in oral argument, that there's other inmates that access booking area. So a trustee is an inmate that is allowed more freedom within the jail to clean and help out in the jail, but then they go back to general population. So certainly somebody of that nature could have gotten access to it if it wasn't found and then taken it back into general population. Mr. Cavello's argument, and I'll let him explain his argument more, but is that that would not have threatened the actual penal institution.
Yeah, these places, Branch County has a new jail. The branch county people handling booking are all professionals. When a person goes back there to have their clothes removed and be checked over, they're watched by at least 3 sets of eyes at all times. I kind of thought this whole thing was, the Court of Appeals said that, oh, people were put in danger. This is routine behavior, routine. There was 161,000 arrests that year where people were brought to jails. And lots of these people have weapons on them. Lots of these people have drugs. And they're caught at booking. That's the job in the booking area. And for them to say it poses some kind of specific danger to the jail, to me, is absurd.
Thank you.
Thank you. Not sure who was up first. You're... Okay, thank you.
Do you think, or do you believe that by widening the description of actions that OV-19 applies to, that it will help make our state safer?
I think that definitely could be a result of it. So they explained what guidelines are before the oral arguments today, and certainly it's somewhat of a confusing topic, but the results of having more individuals scored under OV-19 would be that their minimum sentence that they serve in jail or prison would increase. So the argument could be that by increasing their minimum sentence, there's less people who have a criminal history on the street because they're serving more jail time. So that certainly could potentially increase the safety of the community. But there's also other people that may say it wouldn't. But yeah, I think from the prosecution standpoint, I think it could, yes.
All right, thank you.
Thank you. Go to my right here at the lower level.
Why is possession of meth considered a felony while other drugs are considered a lower class offense?
Yeah, so Michigan and federally, you have schedule of drugs. So you have schedules 1 through 4. A Schedule 1 drug would be a drug that has no use other than abuse. So those are things such as fentanyl, heroin, things of that nature. A Schedule 2, which is methamphetamine, it does have a recognized medical use, but most drugs for possession are going to be at least a 2-year felony. Obviously, marijuana is legal now, so marijuana would not be criminalized unless if you had a certain amount. But if you have heroin, cocaine, fentanyl, methamphetamine, LSD, Percocet, all those drugs are all felonies. They would be 2-year felonies and higher.
All right, thank you.
You're welcome.
Thank you. We'll go to the back on my right.
I'm an attorney, so I don't want to take away from the students. Mark Magyar, I practice civil law in Grand Rapids, but not criminal. So a couple real quick, kind of a two-parter. One is, just for context, what are we looking at in a difference of range if you score 0 versus 25 under OV-19, like the practical impact of the range?
Yeah, so his guideline range as scored was 19 to 38 months. He was sentenced to the top of the guidelines. He was sentenced 38 months. It was actually 10 years. And then if it was changed, it would be 10 to 23 months. So the top of the guideline would be 23 months.
Okay. And we heard Justice Kavanaugh noting that some of the similar scores for different OVs make this a very serious one. It didn't seem like a focal point of the argument was necessarily whether this conduct could be considered threatening to the jail. Is that because precedent already sort of makes clear that having a controlled substance would be threatening? We heard about Dixon and Ward cases. Or is there room to argue that threatening really means like inciting a riot or having something violent happening, similar to the other OVs that result in 25-point scores?
Yeah, so the closest that the Supreme Court has ever come to finding that a controlled substance is inherently dangerous is the Dixon opinion, where they said that there are certain objects possessed within the prison that would be inherently dangerous, such as a weapon. They also mentioned there's 2 published cases from the Court of Appeals that would be Kathy Dickinson and Carpenter, which both found that controlled substances within the jail are dangerous substances inherently. So the Supreme Court actually has not yet specifically decided whether or not a controlled substance is inherently dangerous.
Okay. Thank you.
You're welcome.
I thought that was you back there, Mark, but it's kind of hard to see. So I'm glad you didn't ask why it takes me twice as long to run a marathon as it does you today. So, okay, we'll go to the back on my left here.
I'm Sonny Childs, and I go to school here at Lowell High School. This might have been a redundant question, but I noticed that in the log, it was 2021 and 2022. I was wondering if he obtained that methamphetamine within the prison or outside of the prison.
So the allegations are that he was out on bond when he was arrested for a parole violation. So he was arrested and then brought back to the jail, so he would presumably have gotten the methamphetamine before he was arrested.
Thank you.
You're welcome.
Thanks. We'll go to the lower level on my left here, please.
So I'm short, so I'm gonna have to move this down real quick so I can actually not stay on my tippy toes and say that. So necessarily when we're talking about like probable cause and intentional or unintentional, both of you guys had stated that whether it was intentional or intentional, it would have caused a threat. My question is whether it was intentional or intentional. If it was intentional, like to have the methamphetamine in the booking area, do we necessarily turn a blind eye, even though it could have caused a threat, or do we necessarily take that into account when we do the causes?
Charles, do you want to answer this one or do you want me to answer? Okay. So the question is if the inmate or the defendant intentionally possessed methamphetamine within the booking area of the jail or within the jail, would we still score OV-19 on that? Is that correct?
Correct.
Okay. So yes, I would say the answer to that would be yes, if he intentionally possessed it. And we do have, when I talked about that case Dickinson a couple minutes ago, that was kind of what happened in that case, is the inmate in that case purposely possessed a controlled substance. I think it was heroin in that case. And they did score OV-19 appropriately. So I do think if it's an intentional behavior of controlled substances, which does happen, that would certainly threaten the security of the jail.
Okay, and then I do have a second question, if you don't mind. Sure. So the appellant, I believe, would be the terminology for it, had argued that since, you know, he wanted to or had the methamphetamine on his personnel, but he just didn't necessarily like want to have it on him when he was being arrested. Does that necessarily turn a blind eye? Because I feel like that would be, whether it was intentional or intentional to have it on his personnel while arrested, that could still be a criminal charge because he still wanted to have the methamphetamine on his personnel, whether or not.
It was a criminal charge, and they charged him with it, and they dropped it in a plea deal. So it's not like I'm asking them to ignore that a crime has been committed. What we're talking about here is the level of penalty a person is going to have. It's not whether a crime is committed or not. He's guilty of meth possession, period. So that's a charge. And that's, like the prosecutor said, that's a 10-year felony. But they want to add to his sentence by saying, well, you brought that stuff to the jail. And our position was, well, you picked him up off the street and forced him to go to the jail. You know, so all legal arguments are basically about your rights as a Michigan citizen. Really, people, I know we're going to be asked whether this is a good job or not. These cases aren't really just about Mr. Curtis or Mr. Morris. They're about how are Michigan people going to be treated? And that's what I was asking for. I want a clear line in the law saying if you pick up a person on the street, handcuff them, and throw them in the back of the cruiser, you can't charge them with threatening the security of a jail if he's got something on him that might be dangerous for the jail. That's our position. I think the court should clearly rule on that. And if you notice, Justice Kavanaugh asked a question of the prosecutor right at the end, which was right on point. She said, well, if they had found the meth in his pocket, would that in his clothes later, would he have been charged? It's the same thing. He brought meth to the jail. Why wouldn't he be charged? But the prosecutor didn't have, well, I won't say what the prosecutor said, but that's it. It gets confusing. And this is what I'm asking for all Michigan citizens to be treated alike. Let's have a clear rule, because the law is a little murky. Let's have a clear rule. for example, you could get picked up on the street and have a wrench in your pocket or something, or say you have a knife. Say they pick you up incorrectly, and they take you to jail, and you got this knife in your pocket. Say, oh, that's a threat. That's OV-19 applies to you. My request to them was, stop that. Don't pick up people, handcuff them, arrest them, and then charge them with bringing something dangerous to jail if you're the one bringing them to the jail.
But necessarily, when it comes to that aspect, we all have our free will, and when it comes to threats, it may or may not be intentional. So when it comes to that aspect, do you necessarily believe that the free will applies, since that is a constitutional right? He could have spoken up, and stated that he had that drug on him. So do you necessarily believe that because he didn't speak up, that it should be erased?
It doesn't matter whether he speaks up or not. They're going to charge him. That's why I said the justice's question was accurate. Well, if they find it in his pocket, is that still a threat? If you're bringing meth into the jail, what they're saying is that's a threat. Doesn't matter whether you say you had it, you say you didn't have it, they find it in your clothes, whatever. That's a threat. That's their position. Our position is, if you grab somebody off the street and he's got something on him that shouldn't be in the jail, that's a threat to the jail, you can't add to his sentence because it's involuntary, because the statute requires conduct. The statute isn't flat. It doesn't say bringing something into the prison adds 25 points to your sentence, if you understand. The statute says he or she, by his or her conduct, brings a dangerous substance into the jail. So I was saying, conduct is voluntary. That's what I said.
We have a lot of students lining up, so I think we need to get to the next question, but thank you very much. So I'm going to go to the back, my left here. Can you speak right into the microphone? We're having a hard time.
Hi, I'm Tori.
There you go. Thanks.
I have a question. What is the procedure? Is it different from having a court case in the Supreme Court, like at the hall, or is it a different procedure for having it at a place like this?
That might be a best question for you.
Yeah, no,
so Mr. Covello and mine, this is both of our first time arguing, so we've never had the experience at the Hall of Justice, besides maybe seeing it on other phrases. So
it's pretty much the same. What you're seeing here is just kind of this is only one argument. If we were at the Hall of Justices, there would be several arguments in a row. So you'd have kind of people getting up and down. But there's almost no difference between what you saw here today and what you would see if you came to Lansing and spent some time in the courtroom during oral argument.
Thank you.
Yep, thank you. And then we'll go to my back on the right side, my right side.
So, of course, there's a lot of talk about methamphetamine being a routine drug. Is there a legal precedent of what is routine and what's not routine? And is that is the sentencing changed if something is routine versus not?
So when we look at what's routine and what's not, methamphetamine is always illegal, and it has been for a very, very long time. So do we have a lot of defendants that possess methamphetamine? We do. Is it something that is routinely found all over the place? I would pose that it's not. And when we look at what occurs in the jail, I can tell you as the elected prosecutor in Branch County, I see every case. We have 5 or less of these a year, so that's not really a routine behavior that we see often.
Thank you. And we'll go to my right side here.
I was just wondering, when it comes to OV-19, it was talking about how meth fell out of his pocket, but if it were to come to something like a prescription drug, as an Adderall, if that were to fall out of someone's pocket, that can have similar side effects to meth on someone who doesn't have ADHD. Would that fall under the same designation as OV-19 would, because it can have that threat, or would it not because it's a prescription drug?
Yeah, and that's a very good question. That's one of the issues I believe the justices are trying to figure out. The question was asked by Justice Bolden about marijuana. Marijuana is something legal to possess if you're over the 21. Adderall would be something legal to possess if you have a prescription. So certainly I think that would be something that would be a factually different analysis than a drug that is always illegal for somebody to possess. So, and again, I also think it's context, right? So I gave the example during oral argument about moving it around and trying to hide it. If somebody's trying to do that, certainly that could be a threat because it's still something that can be abused. If it's just something that is more innocently given to the guard, it would be a different analysis.
Okay, thank you.
Thank you. Good question.
Thank you. We'll go to my left, towards the front.
I'm Colt. Can you hear me?
Yes.
Okay. I'm Colton. I just have a question. How do you, it was in both of your guys' arguments, how do you compare something that's legal and controlled, like marijuana, to something like methamphetamine?
Charles, you want to answer this one? You want me to?
How do you, I'm sorry, sir,
How
what?
would you compare like a marijuana versus something like a methamphetamine?
How would we compare them?
Yeah, how do you compare something like marijuana to something more dangerous like methamphetamine?
Well, what the prosecutor and I have to deal with is that the legislature makes laws, and they have really decided to punish methamphetamine very severely because of the alleged harmful effects it has. So that would be, methamphetamine is a level B. A is murder, B is methamphetamine and other crimes, C is cocaine, D is other types of drugs. So now marijuana is, I don't even know if, it's not a crime anymore for most people.
But yes,
It can be, but it's like a D level, and sometimes it's a misdemeanor. But anyway, so the state has arranged levels of criminal penalties, and methamphetamine is at the top of the list. Does that make sense? Is that what your question was?
Sure, yeah.
Okay, thank you. We'll go my left in the back, please.
Wait, is it on?
Yeah, same thing. I think you have to talk right into that microphone.
Hello, I'm Jodine. I was wondering if the offendant knew if the drug fell out of his pocket, if he told the sheriff next to him that if it fell out, if it would still be charged against him.
And that again kind of comes down to the factual dispute. So in the police report, it does not indicate anywhere that he said that, hey, that just fell out of my pocket. At sentencing, when the defense attorney objected to the scoring, the defendant then said, hey, I pointed it out to him. I'm not sure if it popped out of my pocket or not, but I pointed it out to him. All I can really say to that is the trial court judge didn't believe that version of events from the defendant, and he put that on the record, that he just didn't buy that version of it. Now, if he did, then again, that's another factual scenario. And I think when you look at this specific issue, when you're trying to draw a bright line rule, that's going to be very difficult to do because the facts are going to determine whether or not the conduct threatened the security. So, and that's why the people would oppose a bright line rule, because there's always going to be a different reiteration of what occurred in the event.
All right, thank you.
You're welcome.
Thank you. And now on the back, on my right side, please.
Yeah, I'm back again. Even if meth is illegal, why does he have it? And why didn't he admit to it before he was in the booking room?
So that's kind of the age-old question. And what I just said here a moment ago is you guys are asking good questions. This is almost harder than when the justices were asking questions. So I can certainly appreciate it. Unfortunately, we don't really know why people possess methamphetamine besides the fact that there's addiction issues, right? So, people grow up in different lives, people have different lifestyles, are exposed to different things. Methamphetamine is known to be one of the most addictive drugs that we have, which is one of the reasons why it's so severely punished. Why did he have it? I don't know. There's likely an addiction issue potentially. That's why a lot of people would possess it. And that could be the result of why he had it.
Thank you.
You're welcome.
Thank you. And we'll go to the front on my right side, please.
Hi. So, from what it sounds like, the defendant was picked right up off the streets. My question was he just found there? Like, did the cops just find him and say, that's our guy? Or were they like searching him out?
So honestly, I'd have to look back at that original case. So what had happened is the defendant was on parole. So you're on parole if you go to prison, and then you get let out of prison. They put you on a thing called parole, which is supervision while you're out and about. He ended up getting a parole warrant for his arrest. And then when police had contact with him, I want to say it was maybe in a motor vehicle, he then resisted the arrest, which is why he then was arrested again. So he was arrested on the parole warrant and then the resisting arrest. So when he was arrested originally and brought to the jail, it was because he had that warrant out there. So they would have been looking for him in some way, shape, or form.
Thank you.
You're welcome.
Thank you. And then we'll go to the front and on my left, please.
So, with meth being common now, and it being dangerous, and Michigan punishing it so severely, would other drugs like heroin and other less dangerous drugs still apply to this case, or is it just for meth or stuff like that?
Yeah, so I think that was one of the questions that Justice Bolden was trying to get to a little bit of, what about if it was marijuana? And we had another student ask, what about if it was a prescription drug? Interestingly enough, methamphetamine is a 10-year felony. They do consider it very significant. But heroin, fentanyl, cocaine, those drugs are just as dangerous. In fact, I would say more people overdose from ingesting fentanyl or heroin or cocaine than they do from methamphetamine. What happens is when they create laws, they create them at different times. Methamphetamine was created in response to an issue that we were having with that, which is why I think they made it such a high penalty. So I would say that all the different drugs are just as significantly dangerous to one another, those 4 drugs. Now, there's certainly other ones like prescription drugs that if used appropriately would not be as dangerous.
Thank you.
You're welcome.
Thanks. We're almost out of time, so I'm going to let the 3 people who are up ask their questions, but we won't have time for any more. So I'll go to my left in the back, please.
Hi, I'm a senior here at Lowell. I just wanted to know, in terms of, well, obviously he wasn't taken to jail of his own free will. Nobody's taken to jail of their own free will, but regardless of that, he did possess the methamphetamine in the jail. So what kind of precedent would that set if the judges ruled with the defendant in terms of whether he voluntarily had it at the jail or not?
Yeah, and I think that's kind of draws a line between Mr. Cabello's argument and my argument. Mr. Cabello, and Charles, you can correct me if I'm wrong, I believe is asking for kind of a bright line rule to say that if they're arrested and brought into the jail, that should not be held against them for anything that they have on their person. The people are asking that the court does not draw that bright line rule, and that they create rule or clarification on this case that basically if they do something while in that booking process or in the jail, that they should be scored the OV-19. My position, and I put this during oral argument, would be, I think if we create this bright line rule, there's no punishment, I think it starts to minimize the effect and the purpose of OV-19. Charles, do you have anything to add to that?
Well, I just respectfully disagree with the prosecutor. Again, meth is punished, and they charged him with having the meth at the jail. The question is, do you get to throw on this extra penalty? See, he's already going to be facing a penalty. Do you get to add to that penalty, almost doubling the penalty because it was caught and intake where everybody's watching you and you're stripped down and stuff is found on you that you did not intend to bring it to the jail. So yes, I am asking for a bright line to make our lives simpler, lawyers and stuff. And this is really a rule for the public. All these rules apply to you. And so I'm saying if a person is carrying something dangerous on them, but they don't expect to go to jail, you can't charge them for threatening a jail if you're the ones who bring them to the jail. It's, again, I'm trying to protect Michigan citizens from what I think is unfair scoring.
Okay, I'm getting the wrap it up sign, so we'll try and do this as quickly as possible. Go ahead.
My question is, what is
if you could sum it up in like a shorter term, the overall process of how you get a case to the Supreme Court and if the defendant is ever present.
Yes, so that's a good question. So you have the proceedings in the trial court. So, we charge the crime, it goes in front of the court, we have a plea or a jury trial. Once a person is convicted, they're then sentenced. If they pleaded the case, then they have to apply for the Court of Appeals to look at their case. If they go to jury trial, the Court of Appeals will automatically take their case. After the case goes to the Court of Appeals and they issue their opinion, then the defendant has to then apply for the Supreme Court to look at the case. And there's a very few cases that the Supreme Court will take. And when I say apply, I mean they write a brief or they write, kind of a paper, send it over to the court, and the court looks at that and determines if they want to look at that case. In my experience, the defendant is very rarely at these sort of proceedings because there's no testimony, evidence, or anything of that nature. It's all oral argument.
Thank you.
You're welcome.
Although we did have a defendant come to one of the court community connections programs before, so I can tell you that some people will come. Last question. Please go ahead.
I was curious if individuals, when they're stripped in their booking, are they ever actually tested for a drug, like on the traces of it on their clothing, especially those who are known to have prior experience with drugs, or while they're on parole, are they ever tested of their clothes?
So their clothing, not per se, they wouldn't cut a piece of their clothing out and test it, but we do intake drug testing. So they would do a urine test, most likely, or a mouth swab to see if they're under the influence of anything. The Branch County Jail also has a body scanner like you would see at the airport. So they're able to scan the clothing and the body of the defendant to see if he's concealing anything.
Thank you.
You're welcome.
Okay, thank you. Can we get another round of applause for our attorneys here today? Please, if you have additional questions or you were just kind of too shy to ask something in front of the whole auditorium, go ahead and ask the attorneys or the justices at the reception that will follow this. Thank you very much for attending. I hope this was a good experience for you. I would ask that the students please remain in your seats. What we're going to do is get the justices up here, and then we're going to have people will come and escort you up to have photos with the justices. So thank you very much.